Today we will be looking at the distinction between Sharia and Fiqh. Very often we hear people using these terms interchangeably. We hear people talking about according to Sharia, such and such, and they mean according to Islamic law or according to Islamic fiqh or jurisprudence. People say according to Islam, such and such. The tendency is for some to believe that fiqh or Islamic jurisprudence is all with divine authority, that it is unchangeable, that if Sharia refers to the prescribed way of life that is part of divine revelation, then Sharia as Islamic law is unchangeable and doesn't adapt. And that when Muslims want Sharia, what it means is they want to go back to what laws were in the past and avoid thinking about how to adapt laws to present realities. What this type of thinking sometimes does among young Muslims is to kill debate, whereas in reality we find scholars debating on a number of issues related to Islamic jurisprudence. So we would like to distinguish between Sharia and Fiqh. For some scholars, Sharia, as distinct from Fiqh, refers to those divine teachings found in the Quran and in the Sunnah, those clear, explicit, unambiguous teachings that are of eternal relevance to our submission to the will of Allah. Whereas Fiqh or Islamic jurisprudence is what scholars extract from Sharia, what they extract using various tools to arrive at products. So one could look at Sharia as a source and Fiqh as a product, adapting rules and laws to their realities. And just as seasons change, fruits change, the products of extraction or istinbat, as some scholars would refer the process to the process of extracting laws from the Quran and the Sunnah as a human effort to apply these eternal teachings to existing realities. Sharia is much broader than fiqh. Sharia refers to everything in the life of a believer. All aspects of life are covered by Sharia. The articles of faith, the beliefs, or what is called aqidah, akhlaq and behavior, moral action, various aspects of fiqh such as ibadat, devotional acts of worship, and also mu'amalat, our social transactions and mundane interactions. So fiqh really deals basically with devotional acts of worship and mu'amalat or social transactions. It's therefore a subset of Sharia. Sharia is much broader than fiqh. Fiqh is very much tied to the usulul fiqh, to the methodology of extracting rulings from primary and secondary sources. So you can have differences of opinion in fiqh, and we have different schools of thought, while all agree on the same Sharia divine sources. And so if we look at Sharia as divine law or divine guidance, it would refer to those teachings of the Quran and Sunnah that are of eternal relevance, that we are certain about and not open to alternative interpretations. Whereas fiqh is where human fallibility comes in, and we can debate and adapt to changing circumstances. So if we were to represent the difference between Sharia and fiqh with a diagram, it would be the diagram of a tree, where in the soil around the roots we have the Quran and Sunnah, our basic sources of Allah's divine injunctions or Sharia. And we would then have the trunk, which would represent the tools of ijtihad, the processes involved in usulul fiqh, the extractive mechanisms for deriving rulings. And in the branches, the differences within the schools of fiqh, and the final fruit being the fatwa or the fiqh conclusions of scholars. But just as seasons change, leaves drop, fruits also ripen and rot, we also find the fatwas that scholars make in response to the realities around them. Some of these fatwas become obsolete because they belonged to another time and place. Some are ripe and some are not yet ripe. So the debates on fiqh and the need to ensure that all fatwas continue to achieve the objectives of Sharia within changing and expanding societies should never be discouraged, and we should never feel that fiqh is all divine. There are those aspects of fiqh that are clear divine teachings based on explicitly clear injunctions of undisputed authenticity from the Quran and Sunnah. But there's a lot of fiqh that is open to debate, open to a level of speculation, and therefore open to change, to adapt it to new situations. We should therefore be encouraged to question fiqh rulings, to understand what exactly they are based on. When people say according to Islam, what exactly does that mean? Does it mean according to the Quran and the Sunnah undisputedly? Or is it, when we say according to Islam, we mean according to a particular scholar's interpretation? When we say in Islamic law, such and such is the position, what exactly do we mean? Do we mean clear from the Quran and the Sunnah, explicitly clear, undisputed meaning? Or do we mean a product of qiyas, of analogical deduction and human reasoning? Or do we mean a verdict or fatwa or fiqh that is based on ijma or consensus or some other tool of ijtihad? So the key point to remember is to always try and find out, when people say according to Islam, according to Islamic teachings, according to Islamic law, according to Islamic jurisprudence, or even according to Sharia, let us try and find out whether it is really divine teaching that's explicitly clear, or whether there's a degree of human interpretation, human inference, human reasoning, and various tools that form the arsenal of mujtahid scholars or fuqaha in deriving Islamic law. Islamic law is therefore a product of scholars' extraction from Sharia, from the Quran and Sunnah. Not everything in Islamic law is divine. Most of it is open to change as circumstances change, and we should be aware that challenging scholars is not the same as challenging God or his prophet. We don't challenge God and the prophet, but we are ready, and we should be ready, to challenge the opinion of scholars, of course, with humility, with respect, but with a sense of accountability that it is Allah we want to submit to, not the will of scholars.